Is it possible, let's say if I were Michael or Robbie and my parents had been executed and now evidence was revealed which indicated that perjury had been suborned, perjured testimonies had been accepted against them or forged documents, you mean to say that I could not bring a court action to have my parents' wrongful conviction overturned or to demand some kind of review of the evidence? Are they helpless?
The way the law stands today, they are. It is conceivable, but highly unlikely, that that law would be modified. But I think the mistake is in putting the question the way you put it.
I see.
Because the question is not, can you go to court? The question is, can you accomplish the purpose that has to be accomplished through any means? And there is perhaps a more appropriate way, even than a court, for accomplishing this. The objective today is a political one. It isn't a legal one of correcting a wrong. That's generally the purpose of a legal proceeding. Somebody has been civilly wronged or criminally wronged, and you go into the courts and say, give me relief, correct it, release me from prison, take me off parole, pay me a money judgment for the wrong that has been done. None of these things can be done for the Rosenbergs. For the historical purpose, it seems to me that congressional investigation and congressional action is open in many fields and is not only a proper means of proceeding, but is absolutely essential in order to deal with the kind of political tasks that Congress has at least tentatively begun.
Well, what kind of congressional action would you envision?
Well, there are many different kinds. For example, you will recall that when the investigation was opened with respect to the functioning of the CIA, there was a call for broadening that investigation to include an investigation of the Kennedy assassination and any CIA participation in it. They wanted that opening because if the CIA participated in it, Kennedy couldn't be restored to life, but the conduct of the CIA perhaps could be controlled in the future for the very same reasons as one approach. The CIA and the FBI ought to be investigated as to their participation in bringing about this horrible result that they were party to for the purpose of enacting legislation or taking other congressional or executive action which will prevent that from happening again. Now, this is something that can be accomplished, and this is something that historically is terribly important and something that can be utilized at the same time to clear the name of the Rosenbergs.
And I think that, yes, I think in the Rosenberg case is the ideal vehicle to do this because of it being such a great tragedy, in that I think you would spotlight some of the grosser abuses of the federal agencies in this case. I'm bound to believe that they probably went further out on a limb and committed more illegal acts in the course of this trial than you wouldn't find its duplicate probably in any other area. So this would allow, I think, any comprehensive examination of the Federal Bureau of Investigation, the Department of Justice, that would go into the Rosenberg trial would tell you an awful lot about the machinations of the FBI and its interaction with the various other governmental agencies. And therefore, as I say, spotlight the frailties of the organization so that we can not be oblivious of this when we talk about how they operate in terms of restricting them in the future.
Now, I'm going to go to a completely other position here, and I just want to ask you, what if, as the government claims, that is to say, the Justice Department claimed in 1953, at the time of the appeals, just before the execution, that they had far more evidence than had been presented in court, that it was inadmissible for one reason or another, and some people in the government have stated recently that if the files were made public and that evidence came out, the public would be convinced beyond any shadow of a doubt that the Rosenbergs were guilty. What if that were the case?
I think that was that a statement made by Roy-Cohn?
I believe he was one of the people.
Yes, I think Roy-Cohn, you have to know, you know who Roy-Cohn is, I assume.
Not a relative.
But he was related to a fellow by the name of McCarthy, if not by bloodletting. They both participated in the same kind. He is a vicious, despicable, and totally untrustworthy individual. And if he says something like that is true, you can almost bet your last dollar that the exact opposite is true. And he's saying this in the same way that McCarthy talked about, what was it, the 100 communists in the State Department. It has the same sort of validity. Now, there's one other almost certain indication or proof of the fact that they do not have any such evidence unless they forged some documents. The rules of law were completely disregarded in many respects during the trial of the case. And I cannot believe for a second that if they had evidence admissible or inadmissible, it would not have been disclosed and utilized during the trial. And even if that weren't done, when there was the world, when the world was aroused about the possible execution of the Rosenbergs, and it was an embarrassment to the U.S. government, I cannot believe for a second, even assuming the unlikely probability or possibility that they wouldn't have used whatever they had during the trial, that at that time it wouldn't have been disclosed as justification for the murdering of the Rosenbergs.
So you feel that if there was any evidence, even if it was very weak evidence, the government would have thrown it up back in 1953. Now this gets to a point. There was a recent case in this area, a Gary Lawton case. And Mr. Lawton was found innocent after his third trial. And the prosecuting attorney, after the verdict of acquittal, said that he had inadmissible evidence which, had it been admissible, would have convicted him. And this sounds very similar to what was said about the Rosenberg case. Now, this is something that seems to make the public get a little confused. What does a prosecutor mean by inadmissible evidence?
Well, I think it is a camouflage, and it's just on maybe a slightly lesser scale, a duplication of Roy-Cohn's, absolutely irresponsible comment, if in fact he was the person that made that statement. And I would amplify what Ben said by pointing out that I talked to Morton Sobel after he got out of prison, and for years the FBI would send people in to visit him inside the penitentiaries, and they would say that, your wife is going around and seeing a black man and using all their own built-in racism and everything else that they could subject him to try to say, if you will just implicate the Rosenbergs, if you will just make it clear that they were in fact guilty of these crimes.
This is after their death.
This is after their death. Now, if they had all this evidence, there was nothing to restrict it. I mean, inadmissibility would not be a grounds for failing to produce evidence after people's lives had been extinguished on the grounds that they would be denied a fair trial. That's absolutely ludicrous.
So, in other words, if the Justice Department did have evidence which was not admissible in a legal proceeding, they still could have poured it out after the execution to try to buttress their position.
Yes.
If they had anything that they didn't produce, I am confident that it would have pointed to the innocence of the Rosenbergs. You see, there is no purpose or sense in attempting to evaluate what happened from a strictly legal standpoint, because this case was not tried. The motivations behind it were not simply legal, of punishing somebody for the commission of a crime. This was the result of a political Cold War policy calculated to establish that the Soviet Union couldn't possibly have discovered the atom bomb without the help of spies here. It had this political motivation. It was handled as a political case. It was tried as a political case. They were executed as political victims, and any information that could have been used politically would have been used politically.
Well, now, Mr. McKissack, you mentioned Morton Sobel.
Yes.
And this leads me to kind of throw things back at both of you gentlemen. Now, Mr. Sobel was a co-defendant in the same trial. He was sentenced to 30 years in prison. I believe he served 18 and a half years and has been out on probation since then. Parole. Since here you have a corpus for your habeas corpus, could Mr. Sobel demand a retrial or an overturning of the conviction from a strictly legal point of view?
I don't think there's any question that he would have standing to, say, raise the habeas corpus question. The only thing is that one of the arguments that he raised is that he wasn't really properly a part of any conspiracy if it existed, which it didn't. And that he was just sort of thrown in, and the conspiracy law is a dragnet, as it's often referred to. It's so very broad. And as a matter of fact, as I recollect, I think the decision was that he could be a part of the conspiracy. It was a 2-to-1 decision, even given the climate of the times. It was a dissent. He so much on the periphery that, as I say, it would be difficult for him to dig right into the guts of the Rosenberg case. However, in terms of being a potential plaintiff in court, certainly he has he's alive. He's a part of the same case. The only thing is that his petition would really have to show that it would really have to show that his disadvantages that he suffered by virtue of what happened would lead to a reopening of the case, and that he has attempted to do over a number of years, and generally unsuccessfully, to the pitiful point that was made earlier, where Thurgood Marshall, when he was sitting on the Second Circuit, in effect looked down and said, well, there's no relief for Mr. Sobel here, but if Ethel Rosenberg were alive, her conviction would have to be reversed. And that's the position that he's in. You really can't, it's difficult to anchor a lawsuit that would bring out everything that was done wrong to the Rosenbergs, because Sobel, quite frankly, was really not really a part of anything that went to the guts of the lawsuit. He was just thrown in there dangling.
Yeah, except that the only reason that, let's say, a conversation between Rosenberg and Sobel, as reported by Ellicher, who was the only witness that testified to anything involving Rosenberg and Sobel, could only have been damaging to Sobel if Rosenberg were, in fact, guilty, as charged. And so Sobel's being sent to prison based upon having known and spoken to Rosenberg is the reason he went to jail. So then couldn't he have said, well, this whole case was won, the government tried it as one, and I want to overturn the case in total because my conviction is based on the Rosenberg conviction.
I think that's logical, and in fact he has done this and attempted to do it.
But I'm talking about after the files are made public.
Yeah.
You see, would possibly there be information within those files that would make an even stronger argument for Sobel as the only living victim of this?
That sounds promising to me if the right information came forth.
There is a possibility that would happen, and that the courts would listen. The courts have been, and I think will continue to be, very reluctant to reopen this case in any way, and they were likely to use every technicality that they can to prevent its being reopened in the courts. The probability of the courts reopening it, I think, is slight. By this, I don't mean that Sobel shouldn't try, but I think that the courts will use every technicality that they can to refuse to reopen it, and as Lucas pointed out, even though in substance it's one case, there are technicalities which the court can use as a justification, sound or not, but as an apparent justification for refusing to reopen the case.
Well, now, our country is, according to all of its ideals, a country based on laws and not men. However, in this instance, Judge Kaufman, who was the presiding judge in the Rosenberg case in 1951, and sentenced them to death and said that their crime was, so enormous, enjoys a position today in the appellate court system, I believe.
Second Circuit judge. Yes.
He's a Second Circuit judge.
Chief judge.
Now, would he be involved possibly in any attempts to reopen the case? Could he stop it because of being the chief judge of the...
Well, technically, if we're talking about just a matter of law, I'm sure that he would be forced to disqualify himself. But I tend to think we overestimate the power of the legal institutions. I think we've been doing this thing throughout the discussion, as Ben has correctly pointed out, is that, sure, it sounds good on paper to say that, the law is even-handed and it doesn't look at the individual, it just looks at the principle. But this is a case that even the judiciary, they respond to public opinion, often would like to sweep under the rug. I mean, take, for example, the Korematsu decision. You remember the Japanese internment case?
Yeah.
That's still on the books, but to my knowledge, no court has ever referred to it favorably, cited it, would ever use it for anything, or at least hasn't. I mean, they just soon forget about it. It's a case made specially for the occasion and would only be trotted out if it need be.
What if the public were very aroused? What if these files are made public and they do have information, as Michael and Robert Meeropol feel that they do, which points to their parents', if not innocence, at least wrongful conviction, and there is a strong public response to this? Do you think that the courts could be put into a position of overturning the conviction or responding to an appeal?
I think it's possible. I think it's extremely unlikely. I remember the day of the Rosenberg's execution. I was in the Supreme Court that day when the last argument was made to the court. And it was obvious to everyone present that the decision that was made was not a legal decision, it was a political decision. Frankfurter, who filed an opinion, I think, a week later.
2 days, I think, after.
Well, after they were executed, said, why was the court in such a hurry? There were questions presented. Ordinarily, we would at least listen to the questions. We would then decide them one way or the other. But to refuse to even hear questions where a person's lives are involved, that's unheard of. But it isn't unheard of in political cases, and you have to understand that the courts act politically also, and they acted politically in this matter, under a legal guise. Now, to correct this also requires political action. And while the courts are subject to the effect of public opinion, they do react to public opinion, there's no question about it. Congress is much more subject to political pressures than are the courts. And I think that and also you wouldn't have the same kind of technical problems and technical excuses that would be present in the court. Again, I am not trying to discourage the concept of Sobel proceeding in this manner. Certainly, if I represented him, I would recommend that he do so. But looking at it from the broad standpoint, I think it would be a mistake to rely solely upon a proceeding brought on behalf of Sobel. I think the important thing is to move with this political case in the political arena, and of course, we have to move in the legal arena first under the Freedom of Information Act. There you have a good legal case. And then from there into the political arena where it truly belongs, because from beginning to end, it was a political case and it should be corrected politically.
Luke, let us presume, all right, that the files are opened, that this is successful, and that there may or may not be possibilities to get the conviction overturned, or something of this kind. Suppose these files indicate crimes committed, let's say suborning of perjured testimony or suborning of forged testimony. Would it be possible to bring any kind of action under the law against those police or government officials or members of the prosecution who were demonstrated by the files to have done something improper that long ago?
Well, if we were talking about, say, bringing a criminal charge, you have a number of problems there. One is that there's generally judicial immunity. Judges, let's say we're talking about Judge Kaufman, could rely upon that under the existing state of the law. Generally, prosecutors have been immune. There's an interesting case in Los Angeles now where there's been a decision against a particular district attorney having to do with the suppression and distortion of evidence in a case, whether they be suable. But the major obstacle I see there is the question of statute of limitations. It's been so long. We're talking about activities that would have been engaged in over 20 years ago.
Almost 25.
Right. And while in a civil case, sometimes statutes of limitations may not run until the point of discovery, depending upon what we're talking about, is the nature of the lawsuit. In the criminal case, the irony is, of course, their own covering up still allows the statute of limitations to run during the time that they're doing it. You don't have, there just isn't a provision to allow it to be told, or in other words, not run during the time that this stuff is kept hidden. If a defendant, for example, were charged with a crime and he left the jurisdiction to avoid being prosecuted, say he took a trip to Italy and he stayed there, and say it was a 7-year statute of limitations, and then returns to California and says, well, I'm scot-free, the statute of limitations would not be running during this period of time. But there is no provision in the law which says that if a person is clever enough or has the machinery so that he's able to sit on top of certain evidence or make it unavailable for a period of time, that he cannot avail himself of the statute of limitations. In fact, he could. So I think that would not be too fruitful. And again, I think the central point at this late date would not be the question of revenge or vengeance, although I can understand how people might feel that way. I think that the greater concern should be, even if somebody can't be convicted, trying to point out exactly what they did and why it occurred so that we can try to avoid it in the future. And that should be the central aim. So if people wrongfully withheld evidence and perjured testimony was suborned. Quite frankly, the fact that somebody was not put in jail for it would not be a prime consideration as far as I'm concerned, from my point of view.
Well, to me, as just a layman, these are new points, things I've never thought about. And you mean that if a judge performs in a, let's say, criminal manner during a trial, that if he permits something that he knows to be untrue to be presented against the defendant is convicted, and then it comes out that this took place, that the judge is immune from prosecution?
Yes.
As is the prosecutor.
That's a more questionable issue. That can be debated. The question on the judge, that judge issue has been decided a long time ago.
So that if opening of the files should indicate that, let's say, a government agent, let's say an FBI agent, or somebody else who was involved in one of the original arrests of, let's say, Harry Gold or the Greenglasses, someone like this, there have been several points brought out over and over again by Michael and Robbie about the case and by other people, such as an apparently unusual registration card from an Albuquerque Hilton hotel, I believe, which doesn't seem to be quite proper. Or let's say a document signed by a U.S. immigration official saying that Morton Sobel was deported from Mexico, when in fact he was seized by unknown persons at gunpoint and pushed across the border into the hands of the FBI. That the individuals responsible for these documents and these statements, which if they were demonstrated to be forged or untrue, that because a statute of 7 years has passed since the time,
depending on the particular crime involved,
that they could not be prosecuted for this.
I think the basic handicap is the statute of limitations. I think you could fashion certainly a suit under the Civil Rights Act. There are a number of things that you could probably do, but I think it's time that's against you in this situation, just as it's the Rosenbergs' death that's against them in trying to seek relief in the criminal court by a habeas corpus.
There's another factor aside from time. There isn't a day that goes by that demonstrable perjury, demonstrable framing of evidence by law enforcement officials isn't shown in court. I have yet to hear of the first prosecution for it. Have you heard of any?
No.
You mean in all your,
I have never heard of a prosecution of a law enforcement officer for perjury that officer is convicted, has committed, or framing of evidence, although under the laws, procedures could be taken against them. I have yet to hear of the first case.
I think that's not I agree with that sentiment, and I would even say this, that the leading cases that have visited the United States Supreme Court, such as Napway versus Illinois and several others, where they found egregious conduct by the prosecutor, and they have excoriated the prosecutor, and the cases had to be reversed. And there's no question it's been just classified as criminal conduct. I've never heard of a case where a prosecuting agency then chose the prosecutor and made him a defendant in a future action.
Luke, I think you should make it clear that those cases that went up to the Supreme Court were not cases in which the prosecutor was being prosecuted. Yeah. They were the cases where the original prosecution by the prosecutor went up, and the court found that the prosecutor had done just unbelievable kinds of things.
Just a minute. I've been hearing about a case, I believe, down in San Diego, where a man went to prison because his fingerprints were reported found at the scene of a crime. And now, I believe, a policeman, the investigating policeman, detective in the case, has now been indicted, I believe, for having transferred the man's fingerprints from some other source.
Well, I think you're right. And I think that is the first time I've heard of this happening. But I want you to understand that it's every day that this kind of thing goes on. It's flagrant. It goes on all the time, and there's simply... What you're asking is prosecutors to prosecute themselves. Prosecutors do not like to prosecute themselves. But all of the things we've been saying gives additional weight to the value of going the congressional route, because Congress can call these people. They're put under oath. And if they lie, then they are subject to prosecutions now for perjury.
You mean that if, let's say, one of the investigators who, let's say, dealt with Harry Gold 24 years ago, or 25 years ago, actually, it was this back in 1950, before the trial, was called up before an investigating committee of the Congress today and asked certain questions about Gold's testimony at the time. I know there are contradictory tapes which have been played recently. And he denied something, or affirmed something, and it was then demonstrated that he was telling a lie, that he could then be indicted for perjury even though his suborning of that perjured testimony 24 years ago could no longer be prosecuted.
That's how they got Hiss.
Right.
They were after Hiss for alleged espionage, entirely aside from the question of his guilt or innocence. I think his innocence, as I believe, has also largely been demonstrated. But entirely aside from that question, he could not be prosecuted for espionage because the statute of limitations had run. But he was called before Congress. He denied that he had committed any acts of espionage, and he denied certain connections with certain people. And he was then convicted for perjury because he allegedly lied about things that had happened so long ago that they themselves were barred by the statute of limitations. Now that was used, in my opinion, the law was used there for an unjust purpose. But the law can also be used for a just purpose.
Now that
could be used to prosecute prosecutors who lied now about something that happened 24 years ago.
Now this, of course, is a very sardonic possibility. That is to say, the possibility that if Roy M. Cohn, who was the assistant prosecutor and who was still quite a young man, in his mid-40s, I believe, today, or for that matter, Irving Sapool, who was the chief prosecutor, or other Kilsheimer, I believe, if these individuals or any of the FBI agents involved in the case were called up today before a congressional committee or any other legally constituted body that could swear them, and they maintained the positions that they took at the time, or that they had not committed any wrong, and then it could be demonstrated that they had, that the Alger Hiss case precedent could be used against someone like Roy-Cohn today is, of course, is a very sardonic concept, if that's the right word.
Surely could.
You think that
The act of perjury would occur when the person gave the false testimony under oath.
Well, now, this leads me to, I think, getting into your area, the political question. Let us make certain assumptions. Let us assume that the files are made public, that the files contain information or gaps in the information, deleted information, which seems to bring into question the prosecution and conviction of the Rosenbergs. And let us say that this leads to public concern and a possible investigation of some kind. What would be the repercussions upon our legal system and our political system if, in fact, the Rosenbergs were demonstrated to have been improperly convicted? Just theoretical.
I think there might be an investigation and, to some extent, a cleansing of our legal system. I think the impact upon the legal system might be similar to Watergate investigation upon the political system. I think the Watergate investigation, while it by no means solved the problems of corruption in government, certainly had a healthy effect in that area, and I think that the same effect would result from an investigation of what had been done in the judicial area.
You think it would be a good thing?
Oh, I think it would be a fine thing. I think it's an essential thing. You see, I think it is necessary for people to understand what is absolutely a fact in American life, and that is that when it comes to political cases, you cannot trust the judicial system any more than you can trust the political system. And this has been demonstrated time and time again, so that the people ought to know this fact so that they will be more suspicious of and less inclined to support political prosecutions in the future. It would be a healthy thing. It would perhaps slow up some ambitious young prosecutors or old prosecutors, and all in all, it would do a great deal of good. And most of all, if we could uncover what role the FBI and the CIA and other similar government agencies played in this, then there are things that can be done by way of laws and regulations that at least can make it more difficult for the thing to reoccur. It would be a tremendously important thing, and simultaneously, in the name of the Rosenbergs, the names of the Rosenbergs would be cleared from a historical standpoint, and that's all you can do for them now.
Lou?
I concur with all those sentiments.
You think that it would be a beneficial thing to the legal system and to the nation's politics if it were demonstrated that there were questionable
Yes, I think it's important that people understand that the legal system is not so pure, and it has its limitations, and it tends to be inflexible and rigid and can yield a public clamor from time to time. We've seen it in the Japanese internment case that I referred to earlier, in the Rosenberg case, and in political cases. I think that people should be aware that in political cases the system just simply hasn't worked.
Now let's say there's an investigation. Let's say it is demonstrated that there were inconsistencies, inaccuracies, even crimes committed within the case by the prosecution. Do Robbie and Michael Meeropol, sons of the Rosenbergs, or Morton Sobel, have a basis for an enormous multi-million-dollar civil damage suit? One man has spent 18 and a half years in jail. These two young men have had their parents killed. Could they try to get money from the government? Would there be a chance?
You have the same problem with the statute of limitations. The cause of action is barred by time.
Now, what about the black cavalry unit that was accused of having committed a crime back around in the early 1900s? And they were all, I believe, dishonorably discharged from the service, put in prison for some time and all that. This was down in Texas. And then recently came out a few years ago that there was no substance to it. And I think there was one surviving member, and he was given some kind of cash compensation by the government.
Oh, it's different.
Is that, well, how is that different?
Well, so you could go to the Congress. In other words, this would be, and Ben and I have mentioned this, talked amongst ourselves earlier. You could certainly sponsor a bill in Congress and ask that there be recompense paid to the children of the Rosenbergs for the suffering that they've gone through, having to change their names, having to suffer the loss of identities and pretend that they weren't who they were all these years. That kind of, Congress has plenary power to do that. No question. There's a lot of precedent in various areas for rewarding people for damages that they've suffered. And the Congress certainly would be able to do that.
But it would have to be Congress's decision, kind of an act of, I don't know, magnanimity to do this.
Well, it's an act of justice. Congress can sometimes do justice too. It's possible. Doesn't do it very often, but it can.
Well, so you mean, now this again, you see, I say to myself, well, suppose I put myself in their position, okay? Suppose I just got out of the federal penitentiary after 18 and a half years and it was discovered that I was in there improperly. And then you tell me, and I'm sure, you're not in an adversary relationship, you're just as friendly advisors saying you can't do a thing about it.
Well, you know that there have been bills passed giving compensation to persons for things of that kind. That has happened not infrequently. It hasn't happened nearly as often as it should, but there is much precedent for that sort of thing. And in addition, if someone were to introduce a bill proposing such compensation, that bill itself would constitute a basis for a hearing as to whether they should receive the compensation and would be a basis for reopening the whole Rosenberg case.
Now, do you think that the law in this instance is good? I mean, I think that's a lousy legal situation. I think that if I do 18 and a half years in jail or my parents are executed improperly, that I should be able to sue for damages and not have to go to a congressman and beg him to submit a bill to try to help me out. If someone wrecks my car, I can sue them. If someone kills my dog, I can sue them.
Within certain time limits. You see, you have here, as you have in many areas of the law, two conflicting principles. One principle is that if you've been wronged, you ought to be able to recover for that wrong in one way or another. You ought to be able to correct it.
What about where the government, through its prison system and everything else, has inflicted the wrong and has withheld the information that reveals it's wrong?
I would like to see a law passed extending the statute of limitations indefinitely in those situations. But I would not like to see the statute of limitations generally abolished or even shortened.
Now, isn't this?
Or lengthened.
Now, you see, we have in West Germany, for example, there has been a series of extensions of the statute of limitations on war crimes.
Right.
And people are on trial today for things that they did back in 1941, 1942, way beyond the 5 or 7 or 15 years. And whichever government is empowered in West Germany, there's a tremendous public demand, and demand, I'm sure, by people in the United States as well, legal authorities, to do this because of the Nazi crimes being so horrible. And I personally think that an extension of the statute of limitations in anything involving the government as the defendant would certainly be a good law.
I would favor that.
I would too. I think it would have to be very carefully thought out because you have to realize that the government, of course, also acts through individuals, and there comes a point in time, you want to encourage people. We're not talking again about the Rosenbergs here specifically. You're talking about trying to pass a law that makes sense, because you have to be worried about the law being applied in a case where it could reach unjust. I think, but something fashioned along the idea of more lengthy statute of limitations for the government. Taking into consideration the fact that the government is in the unique position of being able to withhold evidence and to do things where the discovery mechanism doesn't go into play in the usual way that things come to light, and therefore
they hide things.
Right, and therefore taking that into account, perhaps a statute of limitations more lengthy, or perhaps a statute of limitations which would not start to run until the discovery of the items which give you grounds for grievance. And that maybe is a point of departure to start the statute of limitations. Something along those lines I think would be quite helpful. But I do think that would be futuristic, and that would certainly not apply to the Rosenberg case and would not be of benefit in this particular situation.
Well, since there are things coming out now, Watergate related and so on, that may be approaching statute time, I certainly would think that it would behoove some member of Congress to start an act going that would extend the statute of limitations when it involves members of the government from the date of discovery of the alleged offense. Because otherwise, this is 1975, some of the Watergate acts may have taken place back in '68.
Some of them are already barred by the statute of limitations.
Mm-hmm. Well, in conclusion, can we say this, that the efforts to reopen the Rosenberg case from a political, public information point of view, according to, as far as you gentlemen can see, should have some degree of success. That is to say that the files will probably be made available to the public or to the Rosenberg sons. But when it comes to the next questions, such as can the conviction be overturned, can an appeal be made from a legal point of view, and then can action be taken against members of the government that may have committed offenses in the trial, you think that these are much more questionable areas of legality?
I think, as Lucas said, under the present law, it simply cannot be done. And while the law does change from time to time, it doesn't remain constant. I would be absolutely astonished if this kind of a change took place in this kind of a case. So I think that the chances are virtually nil, except for the possibility that exists with respect to the Sobel case.
Which is part of the Rosenberg case.
Yes, which is part of the Rosenberg case.
Luke, would you?
My analysis would be the same, and I think that it again accentuates the need to pursue the congressional avenue, because the Freedom of Information Act plus congressional inquiries are bound to garner the information, so that if there was the possibility of a lawsuit, and as I say, I think it would have to be with Morton Sobel bringing the action, then those kind of inquiries would have produced the information that would make that judicial lawsuit more likely to succeed than if it were pursued initially. So any way you look at it, it seems to me that we end up pre-Freedom of Information Act and going the congressional route.
Well, gentlemen, we have been discussing, can the Rosenberg case be reopened? The members of our panel have been Mr. Ben Margolis and Mr. Luke McKissack, both attorneys. I hope that there will be cause in the near future for us to possibly get together again to discuss new ramifications of this case, certainly after the files are opened, the Justice Department files. I want to thank you both very much. This is Robert Carl Cohen. Good night.
I had no idea that they would give them a death sentence. And every time I wrote about it, I would say something. My wife says, look, we're still alive. We have our kids. Everything's okay. I had no idea that they would give them a death sentence. I had no idea that they would give them a death sentence. I had no idea that they would give them a death sentence. I had no idea that they would give them a death sentence. I had no idea that they would give them a death sentence.